Welcome to my news editions. I've been irregular, but come back. Today is the 9th of June, the first day we come back to work from courts. First story I have for you today is that a two-judge panel of the Telangana High Court has reiterated that on disputed questions of fact, particularly relating to title of property, the High Court will not interfere. The court of the Chief Justice and Justice Renuka were dealing with a writ plea filed by the sexagenarian lady who would complain to the court that her name was excluded from the revenue records without following the due process of law. The single judge found that there were multiple disputed questions of fact with regards to title to the property, the ownership, and therefore the expulsion of her name from the revenue records was valid. The division bench said that there was no reason to interfere with the said principle, which has been reiterated multiple number of times, and said that it was open for the petitioner, who was aggrieved by the order both of the single judge and the division bench, and of course the revenue authorities, to go before a civil court and have her rights examined. Justice T. Vinod Kumar of the Telangana High Court took up a case filed by H. Jhansi Reddy. She would complain that there have been repeated posts against her on social media, including Google. She would say that a person by name Upender Singh Nayak, a reporter of Signature Studio, has maligned her with various posts which are defamatory in nature. Her attempt, she says, to have them removed from the space of social networking has been in vain. She's moved the High Court, and the High Court has posted the matter before an appropriate bench for further hearing. GVK EMRI, the emergency ambulance service, is before the High Court, before Justice S. Nanda, seeking review of an earlier order passed by the judge requiring reinstatement of about 187 emergency workers whose services were terminated in 2018. A writ petition was filed by the Telangana State 108 Employees Union, which contended that the termination of the medical technicians, ambulance drivers, and emergency response officers after they had put in more than a decade of service was without the authority of law and was illegal and was in violation of their fundamental rights. Earlier, the judge had allowed the writ petitions and had directed the authorities to absorb their services. They would come back before the single judge, again complaining that there were certain errors apparent on the face of the record when the judge's findings, and they filed a review petition. Justice Nanda jumped the petition, contending that there was no error apparent on the face of the record and it did not warrant a review interference by her. Justice K. Lakshman of the Telangana High Court required the Commissioner of the Greater Warangal Municipal Corporation to conduct an inquiry into the circumstances that led to the demolition of a premises on the roads of Warangal without following the prescribed procedure under the Rehabilitation Act for acquisition of land. The judge was dealing with a writ petition filed by Dr. G. Venkateshwara Sharma, who would complain that his nursing home was partly demolished without acquiring the lands under the Land Acquisition Act or paying him any compensation in lieu of acquisition of the land. He would complain that neither the Rehabilitation and Resettlement Act was followed in its breach. The judge was critical of the manner in which the demolition took place, and he directed that an inquiry be conducted into the manner in which such high-handed action was taken. I'll sign off for the day with acknowledgements to Mani Sahib for helping me out in shooting this and reaching out to all of you. Good day, goodbye.